Good morning, everyone. Hope you can hear us okay. If not, please write a message. We will have our person check out the sound and make sure that you can hear us. But we would like you to mute yourself on your end so that feedback doesn't come through. So welcome. Sitting beside me, I'm Audrianne Adams-Lee from HR Network, and sitting beside me is Shannon Marie Jenkins of TLD Law.
TLD Law, right? Good morning, everyone.
So today we're going to talk about one of your favorite topics, leaves of absence, pay versus leave entitlement, which is always very confusing. And hopefully today we're going to lay this out in such a way that it'll take some of that confusion away from you. So what are the leaves of absence that we're going to review today? Okay. We're going to look at all the federal and state laws and what we have to consider both in leaves and pay. Over there. Give us just a second. We're getting our screen set up properly here. Okay, all set here. All right, so what are the leaves that we're looking at? Well, we have federal and state laws that leaves that we're concerned with. On the federal side, those shown in the light blue triangles, we have Federal Family and Medical Leave Act, FMLA. We also have to be concerned with Americans with Disabilities Act, the ADA. In California, we have a number of leaves. We have the California Family Rights Act, which is almost our own version, California's own version of FMLA. We have pregnancy disability leave, and while it falls under the California Family Rights Act, it has a carve-out on its own. We have the Fair Employment and Housing Act, which makes sure that we do not discriminate against anyone taking a leave. It also has our own version of ADA within the FDHA laws. We have a program called Paid Family Leave, a program for state disability insurance, and workers' comp insurance. And some of these are leaves, some of these are pay. When do they work together? When do they not? And that's what we're really going to try to address today. Oh, there we go. Okay, I like to have everyone think about two columns when you're thinking about a leave. One column is what kind of leave is the person qualified for, and the other column is what kind of pay can they receive while getting that leave. So before we can think about pay, we first have to consider what is the situation and what kind of leave do they qualify for. And we're not going to get into as much about what the leaves mean today. That's a different seminar, but you know, FMLA just is for care of self or families, a family member that needs cared for who may be ill. CFRA, California's version of FMLA, is also the same thing, but CFRA has an added component that allows for baby bonding after pregnancy. So you could end up taking a CFRA for yourself, for illness, or for a family member who's ill, or for baby bonding after pregnancy. PDL, pregnancy disability leave, strictly for a woman while she is disabled due to pregnancy. So as long as she's under a doctor's care due to pregnancy, she would be on PDL. Once the doctor releases her, even if she continues her maternity leave, that would be something else. It wouldn't be disability under pregnancy. And we'll talk about where we go from there. Workers' comp insurance, everyone's covered by an insurance plan if they get injured or ill at work. And so their leave would fall under the workers' comp insurance. Someone may ask, and you may allow them to take a personal leave. whether they just want some time off to backpack in the mountains, and clear their head, or they may not qualify for FMLA or CFRA but need to take care of a family member, and you've opted to let them have some time off. They may have a personal medical leave. Again, if they don't qualify for FMLA or CFRA, maybe for employers who are under 50, they don't have FMLA or CFRA. So you might choose to let somebody take a personal leave or a personal medical leave. And then ADA, Americans with Disabilities Act, and FEHA, Fair Employment Housing Act, is not a leave in itself, but it is associated with leaves because we have to try to accommodate employees who have an injury or an illness and who take a leave. And then now we have sick leave. That's now a paid leave in California, up to 3 days. So the employee comes to us and they tell us, I have a situation. Either I have to get a surgery, for example, or my family member's having a surgery that I need to take care of, or I'm pregnant. So we look at what do they qualify for on the left side. Once we've identified what they qualify for, then we can see how they might get paid. And we would guide them on that. A lot of the pay programs are through the state, so they have to go directly to the state to apply for any kind of pay program. So for example, under FMLA, if I was taking it for myself because I was ill, injured, on some kind of medical leave, then I could collect SDI, State Disability Insurance. And State Disability Insurance runs for up to 1 year. If it was for a family member, I could collect paid family leave. Paid family leave is a pay program through the EDD, and it's up to 6 weeks. So while FMLA is a 12-week job protected leave, paid family leave of the pay program is for 6 weeks. That means if I were to take my entire 12 weeks of FMLA, only 6 weeks of that would be paid and 6 weeks would be unpaid. CFRA. So CFRA runs the same as FMLA, and if it's not a pregnancy issue, FMLA and CFRA run concurrently. They run at the same time. So when you designate the FMLA leave, you will also designate the CFRA leave at the same time. And the same type of pay applies. So if it's for yourself, you're injured or ill, then you can collect SDI. If it's for a family member, you can collect paid family leave. Okay, next is pregnancy disability. So again, because a woman is disabled while under a doctor's care and pregnant, she can collect state disability as long as she's under a doctor's care. Now, what's interesting is California doesn't allow CFRA and PDL to run concurrently. So what that means is you will have FMLA start while PDL starts. Once PDL ends, CFRA takes over. So in this case, let's say we have a woman who's pregnant, and it's up to 4 months or 88 working days for pregnancy disability, and again, up to 12 weeks for CFRA, because it's the same as FMLA. So let's say a woman happens to be out the entire 4 months. She had a pregnancy where she had some complications, and the doctor put her out for the entire 4 months. Then he releases her, and she says, I want to take my 12 weeks of CFRA leave for baby bonding. In this case, we would designate an FMLA leave and a pregnancy disability leave. The FMLA would run out after 12 weeks. The pregnancy would extend to the full 4 months, and she could collect SDI. Then her CFRA would start for 12 weeks. Because she's not ill, she can't continue to collect SDI. That's only for illness, but she could collect another 6 weeks of paid family leave. Okay, let's go on. Workers' comp. Workers' comp is the only leave that is also a pay program. So if I'm on workers' comp for a work-related injury or illness, I'm also collecting pay, partial pay, from workers' comp insurance. So that one's pretty straightforward. Personal leave. If I were taking a personal leave, let's say for a family member, then I could collect 6 weeks paid family leave, PFL. If I'm on a personal medical leave, again, because I'm because it's medically related, I can collect SDI. So let's talk, and then sick leave is, as we know, you're required to give at least 3 days sick leave per year per employee. And that one's, I think, pretty straightforward. Let's talk for a minute about ADA and FEHA. So what both ADA and FEHA say is that you must try to accommodate anybody with an illness or injury that is either unable to do major life functions at their job, continue to do the essential functions of their job. It impairs their major life functions. And part of one accommodation that often is provided is the leave itself. So that is an accommodation. They may need a partial leave or an intermittent leave, and that's actually going to be our next hotspot. So we're not going to get too into ADA and FEHA today, other than to know that anytime somebody takes a leave, we want to accommodate them. That is part of the accommodation. Now, one thing that's kind of interesting and is clients will call and say, okay, their 12 weeks of the FMLA is up. Can I terminate them now because I don't know when they're coming back to work? And we will always tell you, and I think Shannon will probably agree, we're going to say, did you go back and do the look at if the reasonable accommodation can be made? Have you had an interactive process? In other words, a conversation with this employee to determine if an accommodation can be made. If we find out that a doctor says they can come back part-time, they'll be back in 2 weeks, etc., it's going to be real hard to prove a hardship when you've been accommodating them for 12 weeks at this point all along. You really are going to have to show that it's a hardship. And generally, we don't recommend that you do consider termination until after a second extension, or when you receive a second extension beyond once their legally required leave has exhausted. Yep. Okay. Anything you want to say on that? Okay. So let's look at some charts that hopefully will help you a bit.
Before we get too far into that, just a couple of points to make, things that we're not necessarily going to have time to cover today, but things that you should be aware of, at least spot the issues so that you can contact either Audrianne or myself to talk a little bit more about it. The first thing is, if there is no type of pay available, SDI or PFL, you're going to have people, you can either mandate, or with some leaves, you can make it available for them to use other types of pay replacement. This could be the vacation or the PTO, or the sick leave. So even though it would ordinarily be unpaid leave, if they have time in their banks available, you can sometimes mandate and sometimes make available these other types of pay to substitute that. One of the things that you're going to want to consider, and that your handbook should already cover, is what is the effect on benefits accrual and availability while you're in a leave situation. And Audrianne and I always make sure that it's important that we include in the handbook a discontinuation policy. In other words, if you are providing health insurance benefits after a certain period of time, you make sure that you state in your handbook that you can roll the person off of those benefits and onto COBRA, because otherwise that would continue indefinitely, especially for a workers' comp leave that could go on, as we know, for years. And then one of the interesting things that Audrianne and I ran into for leave situations recently is what effect that a leave has on a salaried worker's ability to receive wages. And we actually consulted with the EDD on this, and it's looking like it says that you can not pay an exempt person their wages if they are on a bona fide leave, and that's not going to affect their exempt status. That was a question that we had, whether or not we had to at least make sure that they met that salary basis each pay period, but it looks like that's not going to be the case. If they're on an approved and authorized leave, it looks like that you're going to be able to make that deduction from their wages without affecting their exempt status. So the leave situation itself creates a lot of issues that you definitely want to make sure that you look at.
Good point, Shannon. It reminds me of something else too, especially when we talk about unpaid leave, because both SDI and PFL have a 7-day waiting period till the pay kicks in. And so employees will often ask, what can I do to supplement my pay for that first 7 days? So again, some leaves allow you to require them to use vacation slash PTO and or sick, and some say that you can make it an option to the employee. So again, refer to your handbook, and if you're not sure, just give us a call. Okay, so let's look at a couple things. So a few reminders. So FMLA and CFRA can run concurrently, but not if there's if there's no PDL involved, no pregnancy disability involved. So if somebody's out for a non-pregnancy related illness and requests an FMLA, you're going to designate both an FMLA and a CFRA. Remember though, CFRA and PDL cannot run concurrently. So in that case, you would have FMLA and PDL together, and once the PDL ends, CFRA can start. Somewhere along there, the FMLA will run out as well, but you want to start that FMLA clock ticking at the beginning of the pregnancy leave. Workers' comp and FMLA run together. They run concurrently. This is something I find most employers overlook. So it's really important that if somebody goes on a workers' comp, you also designate it as an FMLA, because remember what FMLA is leave for your medical condition. That's one of the reasons you can use it. And even though it's work-related, it's still a medical condition. Why is this important? Let's say an employee is out on a workers' comp leave for 6 months. They come back and they say to you, by the way, I need to go take care of my mother in Nebraska who fell and broke her hip, and I'm going to take my 12 weeks FMLA. If you had not designated their prior workers' comp as an FMLA and ticked the clock away, ticked that 12 weeks off for the prior 12 months, you are on the hook to have to provide them now another 12 weeks FMLA. So that's really important. On the pay side, you can't collect any money from the state from 2 different programs at the same time. It's that simple. It's just one at a time. So I can't collect paid family leave while I'm getting SDI, okay? The only case where I can get SDI then paid family leave is for pregnancy, okay? I'm pregnant, I'm disabled, the pregnancy is over, the doctor's released me, I'm going to take baby bonding. Now I can go and apply for paid family leave. You can't collect workers' comp and SDI at the same time because, again, it's for the same injury. If it's an injury that's already covered under workers' comp, SDI will not pay it. Okay? All right. So here's a leave timeline, again, to kind of help you see an illustration of it. This is a woman who's pregnant. And as you can see at the top, she's pregnant for the full time. We designated the FMLA. I'm just going to point this out. So we designated the FMLA. It goes for the first 12 weeks. Pregnancy goes for up to, it's 18 weeks, 88 working days, 4 months, in that range. So we can't start the CFRA until the pregnancy ends. Pregnancy ends, now we can start 12 weeks of CFRA, okay? That's the leave portion. What's the pay portion? As long as a person's disabled, they can collect SDI. So as long as she's on pregnancy disability, she's collecting SDI. Then that ends, there's a 1 week waiting period, a 7-day waiting period. So it's a week and 2 days, and they can start collecting paid family leave. And paid family leave for 6 weeks. So again, you can see that they would only be collecting it for a portion of their CFRA. Some people will only take CFRA as long as they're getting paid family leave because they can't afford to be off work with no pay. But as they can work it out, they can get up to another 6 weeks off beyond their PFL for baby bonding. Okay, we're going to look at it in another way. Again, just trying to help understand all this. So here's the same leave. We have our pay side and our leave side. And as we can see, somebody who's pregnant, as long as they're disabled, up to 4 months. The first 12 weeks, they're also on FMLA. We've designated the FMLA leave. And once the PDL ends, then we collect CFRA. Notice here it says job protected, okay? You cannot discriminate, retaliate, or otherwise take any adverse action against somebody who is on a job protected leave. So how do they get paid? We go to the pay side. So as long as they're on PDL, they can collect SDI. Then when SDI ends, they can collect 6 weeks of PFL, 6 weeks of unpaid leave, assuming they took the entire 7 months. Let's look at somebody who's not pregnant, just regular medical leave. So we would designate both FMLA and CFRA for this 12 weeks, job protected. And if it's for themselves, they can collect SDI if it's self who is disabled, and they can collect that as long as they're disabled. So even if their job protection right ends after 12 weeks, they will still collect SDI for up to 1 year as long as they're under a doctor's care. If it's for a family member that they're caring for, they can collect PFL for 6 weeks, and then the additional 6 weeks would be unpaid. Okay, so as I said, our next hotspot is on intermittent leave as an accommodation, and that's just opened up a whole new can of worms, and we've seen a lot of activity around this over the last year or so. So we felt like it was important to kind of talk about what is an intermittent leave, what's a reduced leave schedule, what do I have to accommodate, what do I not have to accommodate. So we're going to touch on all that. Any questions? Maybe if you did have a question, you're welcome to either email myself, aadamslee@hrnetworkinc.com, or Shannon Jenkins, sjenkins@tldlaw.com. All right, thank you everyone for participating today, and hope we'll hear back from you and talk to you again on the 21st when we'll be talking about intermittent leave as an accommodation. Bye-bye.